ensure it is published. It's actually a very well reasoned, and it should guide future prosecution or bond applications of such nature. Your Honor, we are grateful for the bond terms that you have indicated. Your Honor, we would want the court to take judicial notice that, of course, processing of bond is a time-consuming process. Such that it is not humanly possible to even try and be able to process that bond today being a Friday. And Your Honor, we had indicated, and there is a medical report, Your Honor, which I don't know if the court was privy to. And this report, Your Honor, has been available pursuant to your directions. And Your Honor, if you look at the first page, the third paragraph, it's clear that the accused person has raised issues actually. The indication is that he has a broken wrist. And Your Honor, there is even a scan which was available to court yesterday of that. But more importantly, Your Honor, on the last appearances you've given orders to be taken to hospital, there's been difficulties. So that today being a Friday, they will tell you it will be so difficult. Maybe we can't have more issues. We are praying, Your Honor, because of the unique circumstances of this matter, Your Honor, that you make an exception, Your Honor, that your decision can remain, but you can vary it, Your Honor, that if the family can deposit a logbook in court the way in its nature today, Your Honor, the accused person can be released pending processing of that, so that he's able to at least attend medication and also to be able to eat. If we take him for another 2 days, Your Honor, it will be so difficult for him because he's unable even to eat, and the issue of medication is an issue. So we do not want you to interfere so much with this, because I would have been making a request that you vary your orders and maybe consider a cash bill, but I take wisdom in what you have indicated. But just to facilitate that, because the essence is that you've already accepted, and we are grateful that he be granted bond, he can actually come out. But just because of the unique circumstances, Your Honor, either they deposit an amount, Your Honor, that maybe can act as assurance pending processment of this, even if it is maybe 200,000, Your Honor, just to hold on to the processing of this. And we can have a mention, Your Honor, even on Tuesday, so that he can also be in court and we can just follow up, just in the best interest, because then under the Children's Act, parental responsibility will extend up to 21. So, Your Honor, in the eyes of that law, we will still treat him, Your Honor, as a child. That's all we are seeking, and he will still be within the control of this court. That is all.
Your Honor, this is to also join the defense in thanking you for that prudentially grounded ruling, and ask that things that are not on trial, such as the car, be released back to the mother. The car has been detained at Kasarani police station, and when we asked, Your Honor, we were told that they have not taken a photo of the car. Now the 5th day they have been unable to take the photo. This court gave the order that it be released to the door. But they have given us the 2 phones and the laptop. However, they have not given back the charger, and they are alleging that they left it in the room which the accused person has not accessed in the time of arrest. We'll give them benefit of doubt. And the next mention will update the court whether they left the charger in the room or it was part of their story. But for the car, the mother needs it urgently. She cannot survive without it. It is part of her income.
Donna, I hope the defense is done so that I don't get another attack from my very good friends. I'll start with the last point on the motor vehicle. The danger of coming late to court is what my learned friend, Mr. Chesa, is suffering from. My colleague says they'd already agreed about the release of the motor vehicle, Ms. Karaoke and Mr. Okachi. So that is already done.
So it will be released
to the mother once they process.
Once they take the photos.
Once they finish processing. Mr. Chesa should just let the administrative part also just happen. They already discussed it with counsel. We oppose, however, unfortunately, we oppose the release of the accused person prior to the compliance with the bond terms for the single reason that bail and bond is complete when the orders of release of bail together with the compliance of the conditions and terms. And that's why 49(1)H talks about release on reasonable conditions. So when a court sets reasonable conditions, especially where the court is very express that it is not giving an alternative of cash bail, it would beat the whole purpose of the conditions set by court. Again, it would also have the effect of preferential treatment for one suspect or accused over all other accused persons who have appeared before you. And it would also open a floodgate. You know, we are going to likely see similar applications where bond is given and people are able to review indirectly bail terms. So for the danger, to avoid that danger of the floodgate, and to also appear to review bail terms as soon as they are granted, when the condition for review of bail is that there has been a change of circumstances. We will oppose the release, but we are ready to actually judicially approve bail if it's ready right away. The three of us, one of us can just remain here to help approve if they are ready for approval. But we take it very seriously that we oppose the attempt to review the bail terms as soon as they have been granted. Thank you.
Yes, Your Honor, my good friend has told you that these will be imitated in other, or he's comparing it to other cases. Your Honor, cases are dealt with as they come. Circumstances are different, Your Honor. And that is how cases are dealt with. We have given you circumstances, Your Honor, to urge you and convince you to treat this case differently based on the circumstances before you. Your Honor, you are told by my brother that it will be absurd that you are going to review your directions or orders immediately after it has been issued. Your Honor, we call him JV law, but he cannot create law. We are guided by laws in this country. So, Your Honor, unless he points you to a particular section that binds your hands, I'll tell you that once we have convinced you, you still cannot, your hands are bound, are tied. Then, Your Honor, that is what you have just called here rhetoric, things that cannot persuade you. But more importantly, Your Honor, because of the aspect of time, Your Honor, in terms of even a review, Your Honor, the cardinal issue is there new material that has been availed before the court that the court did not have at the time of making its decision? That is the cardinal question that guides even an application for review. Your Honor, we have availed a medical report that the court ordered for in its wisdom. This report, Your Honor, was not before the court, or was not within the knowledge of the court while the court was writing this decision. And these are medical experts, Your Honor. They are now telling us this is the difficulty. And based on that, Your Honor, this is new information that we beg the court to find that it is proper for the court to reconsider that decision that you gave, which we are grateful for, but in line with the aspect of the health and the life of the accused person. The Constitution says, Your Honor, that life is one of those particular rights, Your Honor, that cannot just be fettered like that. This is a life. And we are looking at that particular aspect now. They say, you are what you eat, but food is life. This person cannot eat, Your Honor. That's all we are saying. At this particular point, you've been told he has a jaw issue. It's fractured. All we are saying, Your Honor, he will meet. But in the circumstances, Your Honor, kindly vary. And it has been done in this court, Your Honor. Parties have been able to post, to even give cash, and it is processed the next day or the other day. It has been done in this court, and I've been part of it. So it won't be breaking news for any person or JV law station. It cannot be breaking news. It has been done. And for very people who have names in this country, so for this young man, Your Honor, we are just asking, it's a weekend time. Very, very kindly. Based on what our good doctors have told us. We thank God they are not on strike. They've given us this.
Your Honor, I apologize. I know I'm breaking protocol, but I was just about to say one thing before the defense court, so kindly permit me just 1 minute. Yeah, for the from the family of the complainant. Number one is that I want to associate myself with the submissions of my landed senior prosecution counsel, Mr. Njoroge, in opposing the accused person from being released before the orders are complied with. The court has just read. But in addition to that, Your Honor, I would like to point out what I would like to expound more on what the just said. It will be an aspect of discrimination. Remember, the complainant is equally undergoing a medical process, and this ruling was read without his input in form of the probation report. So, Your Honor, we would like to oppose.
From the complainant. There was input from the complainant. You were present, Mr. Omari was present.
Your Honor, I've just read the report, and I didn't see that, but
No, I'm saying I've not considered that report. I've pointed out in my ruling. I've not considered it because by the time it was being availed to me, it was past 2:30 and already the ruling was out. So there was no way I would have inculcated it in the ruling, whereas I'd already.
Okay,
So the segment of the complainant was already incorporated.
okay, Your Honor.
You were here when Mr. Omari was
Crying.
Okay, Your Honor, I really sympathize with the accused person's medical condition,
Yes.
but I join my landed senior JB's submissions in opposing the application that the defense did.
Okay. Alright, so I've appreciated the application for review, but I think at this stage, I will not entertain the same in the form of reviewing it at this point in time. Obviously, having just read out my decision, I believe there is no law, but I think it would be tenable that immediately, and I've expressly stated that there will be no alternative for cash pay, and then immediately I grant a cash pay. So I think there are facilities within our remand facility that we can take care of this, that I empathize with it. I totally empathize with it. his condition. You can see he's really in pain. So they take really empathy on that. As for now, will not interfere with the finding of my ruling. So I think I rest at that.
Much obliged for it. Your Honor, we are grateful and thank you for the time you provided us in this meeting. Thank you so much.
So similarly, let me thank each one of you. I think it has been very lively. We've had very, very jurisprudential arguments. And I want to thank you. And we hope he gets well soon. And I thank you for your cooperation, for your decorum. And I wish you well. Have a good evening.
Thanks.
Yes, please.
Oh, sorry.
You know, we also file a result. We have handed over the 2 points. So the 2 points. 23 June.
So we are proposing the 15th of June.
Yes.
15th of June for mention of the ground.
It's okay because it's a mention.
Yes. All right. So thank you. Have a good evening.
Same to you, Your Honor.
Who has the original report?
The doctor.
Mwenye
Sikuwa nimeelewa swali kwa secretary. Monday ndio siku ya mwisho kumpatia maharagwe tunamchukua. Very fine, and you?
Ian, msimamo. Oh, you are here.